Thank you for visiting the Waterkotte website and our YouTube channel. Our criminal defense law firm in Illinois has over 400 perfect reviews and a long history of client satisfaction, dismissals, charge reductions, and victories. We have created these audio articles to help protect your freedom, reputation, and rights. If hired for your case, we will not give up until you get fair justice. Violent crimes lawyer in Southern Illinois. Being accused of a violent crime in Southern Illinois is a serious matter, one that can change your life forever. You may be facing years in prison, a permanent felony record, and consequences that affect your family, freedom, and future. Waterkotte's Southern Illinois criminal defense attorneys have a strong track record of fighting and beating violent felony charges. Whether you're under investigation or already arrested, we act fast to protect your rights and defend your reputation in court. What counts as a violent crime in Illinois? Under Illinois law, a violent crime is generally defined as any offense that involves the use or threat of physical force against another person. This includes not only serious felonies like murder and rape, but also crimes such as aggravated battery, domestic violence, and armed robbery. Even threats of harm without actual injury may be prosecuted as violent crimes depending on the circumstances. Charged with a violent felony? Call Waterkotte at 618-88-CRIME to speak with a violent crimes defense lawyer today. These offenses carry heightened consequences because the state treats them as crimes that endanger public safety. As a result, those accused often face mandatory minimum prison sentences, restrictions on bail or pretrial release, limited plea bargain flexibility, labeling as a violent offender on your criminal record. The classification of a crime as violent can also influence everything from sentencing enhancements to parole eligibility. Prosecutors and judges take these charges seriously, and so should you. Key takeaway: in Illinois, the violent crime label doesn't just mean serious penalties. It means prosecutors will fight harder, and your defense must be stronger. Talk to a Southern Illinois criminal defense lawyer as soon as you're charged or investigated. Penalties for violent crimes in Southern Illinois. A violent crime conviction in Illinois doesn't just mean jail time, it can permanently alter your life. These charges often carry some of the harshest penalties in the criminal justice system, especially if the offense involves a weapon, injury, or vulnerable victim. Criminal penalties. Class X. Felony, 6 to 30 years in prison, no probation. Class 1 or 2. Felony, 3 to 15 years in prison, depending on the offense. Extended terms may apply for repeat offenders or serious bodily harm. Life-altering consequences. Permanent felony record, often non-expungible. Loss of gun rights under state and federal law. Mandatory registration in some sex-based violent crimes. Severe immigration consequences for non-citizens. Social and professional fallout. Disqualification from many jobs, housing, and loans. Damage to reputation and family relationships. Restrictions on parenting time or custody rights. Key takeaway: even after serving time, the impact of a violent crime conviction lingers. That's why a strong defense now is your best shot at protecting your future. What to do if you've been arrested for a violent crime in Southern Illinois? Being arrested for a violent crime in Southern Illinois is one of the most serious events you can face. Whether the charge involves assault, robbery, or something more severe, your actions in the first hours and days can have a major impact on your case outcome. 1. Do not speak to police without a lawyer. You have the right to remain silent. Use it. Anything you say can and will be used against you. Politely but firmly invoke your right to an attorney, and decline to answer questions until you've spoken with one, and have one by your side in the interview room. 2. Comply without resisting. Even if the arrest feels unjust, do not resist. Physical resistance can lead to additional charges or escalate the situation. Stay calm, stay silent, stay polite, and wait for legal representation. 3. Request an attorney immediately. The sooner you have legal guidance, the better. A Southern Illinois violent crimes lawyer can argue to reduce your bail, protect your rights, and begin investigating the charges before evidence is lost or distorted. 4. Document everything you can remember. Write down the details of your arrest and the events leading up to it. Who was there? What did they say? Were there witnesses or cameras? Your notes can help us reconstruct the incident and identify holes in the state's version of events. 5. Avoid contact with the alleged victim. Even indirect contact through friends or social media can lead to additional charges or a violation of bond conditions. Let your attorney handle all communication and defense strategy. Key takeaway: the first 24 hours after your arrest are critical. A skilled Southern Illinois violent crimes lawyer can help you avoid missteps and start protecting your future immediately. How we defend violent crime charges in Southern Illinois. Every violent crime case is different, and your defense should be too. Our violent crime defense lawyers in Southern Illinois start by listening to your side of the story, reviewing the evidence, and identifying the prosecution's weaknesses. From there, we build a strategy tailored to your circumstances, the local court, and your long-term goals. Common legal strategies we use: challenging the credibility of witnesses or alleged victims, showing that you acted in self-defense or defense of others, highlighting procedural violations or constitutional rights breaches, disputing intent, especially for charges like first-degree murder or aggravated battery, exposing flaws in forensic or digital evidence, filing motions to suppress illegally obtained statements or evidence. We also handle pre-charge investigations. In some violent crime cases, we're retained before formal charges are filed. If you're being investigated or have a warrant out for your arrest, don't wait. Early legal intervention can sometimes prevent charges from being filed at all or steer the case toward less severe outcomes. Key takeaway: prosecutors often rely on emotion and pressure to secure violent crime convictions. We cut through that with facts, strategy, and aggressive courtroom advocacy. Types of violent crimes we handle in Southern Illinois. At Combs Waterkotte, our criminal defense attorneys have successfully defended clients across Southern Illinois, facing a wide range of violent crime charges. From first-time arrests to complex felonies, we bring aggressive, personalized defense strategies to each case. Violent offenses we defend: first-degree murder and attempted murder, voluntary manslaughter and involuntary manslaughter, aggravated battery and aggravated assault, armed robbery and aggravated robbery. More violent crime charges: kidnapping and unlawful restraint, domestic battery and aggravated domestic battery, vehicular hijacking and carjacking, aggravated arson and hate crimes. Why choose Combs Waterkotte for your Southern Illinois violent crime defense? We've built a reputation across Missouri and Southern Illinois as the go-to firm for serious criminal cases, especially those involving violence. Our team doesn't back down from complex, high-stakes situations. Instead, we bring clarity, compassion, and courtroom firepower to every case we handle. When you work with us, you get proven results in felony trials and pretrial dismissals, access to leading investigators and expert witnesses, personalized defense strategies based on your goals, responsive service. We're available 24/7.